ಎಲ್ಲರಿಗೂ ಶುಭ ಮುಂಜಾನೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ KSBC ಲಾ ಅಕಾಡೆಮಿ ಇವರು ನಡೆಸಿಕೊಡುತ್ತಿರುವ ಬೆಳಕು ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಗೆ ತಮಗೆಲ್ಲರಿಗೂ ಸ್ವಾಗತ. ಈಗಾಗಲೇ ಬೆಳಕು ಕಾರ್ಯಕ್ರಮದ ಬಗ್ಗೆ ವಿವರಣೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ವಕೀಲರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿ ಸಮಾಜಕ್ಕೆ ಒಳಿತನ್ನು ಮಾಡಿ ದಿವಂಗತರಾಗಿರ್ತಕ್ಕಂಥ ವಕೀಲರ ಬಗ್ಗೆ ಅವರ ನೆನಪಿಗೋಸ್ಕರವಾಗಿ ನಾವು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮವನ್ನ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಇಂದಿನ ಉಪನ್ಯಾಸಕ ಮಾಲಿಕೆ ಶ್ರೀಮತಿ TN ಮಂಜುಳಾದೇವಿ ಇವರ ನೆನಪಿಗೆ ಮಾಡತಕ್ಕಂತ ಒಂದು ಕಾರ್ಯಕ್ರಮ. ಇಂದು ಮಹಿಳಾ ದಿನಾಚರಣೆ, ಇದಕ್ಕಿಂತ ಒಳ್ಳೆಯ ದಿನವನ್ನ ನಾವು ಕಲ್ಪನೆ ಮಾಡ್ಲಿಕ್ಕೂ ಸಾಧ್ಯ ಇಲ್ಲ. ಶ್ರೀಮತಿ TN ಮಂಜುಳಾದೇವಿ ಅವರು 1947ರಲ್ಲಿ ತೀತಾ ಕೊರಟಗೆರೆ ತಾಲೂಕು ತುಮಕೂರು ಜಿಲ್ಲೆ, ನನ್ನ ಜಿಲ್ಲೆಯಲ್ಲಿ ಅವರು ಜನ್ಮ ತಾಳಿದ್ರು. ಅವರು ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಪ್ರಥಮ ಮಹಿಳಾ ನ್ಯಾಯಾಧೀಶರಾಗಿದ್ರು. ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಥಮ ಮಹಿಳಾ ಸರ್ಕಾರಿ ವಕೀಲರು, ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಮೊದಲ ಮಹಿಳಾ ಪದಾಂಕಿತ ಹಿರಿಯ ನ್ಯಾಯವಾದಿ ಅಂದ್ರೆ ಡೆಸಿಗ್ನೇಟೆಡ್ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್, ಕರ್ನಾಟಕ ಆಡಳಿತ ಮಂಡಳಿಗೆ ನಿಯೋಜಿತರಾದ ಪ್ರಥಮ ನ್ಯಾಯಿಕ ಸದಸ್ಯರಾಗಿದ್ರು. ಕರ್ನಾಟಕ ಮಹಿಳಾ ಒಕ್ಕೂಟಕ್ಕೆ ಕರ್ನಾಟಕ ರಾಜ್ಯದಿಂದ ಚುನಾಯಿತರಾದ ಮೊದಲನೇ ವೈಸ್ ಚೇರ್ಮನ್, ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ನಲ್ಲಿ ಪ್ರಥಮ ಸಂಧಾನಕಾರರು. ಇದಕ್ಕಿಂತ ಹೆಚ್ಚಾಗಿ ನಮ್ಮ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಸದಸ್ಯರು ಕೂಡ ಆಗಿದ್ರು ಅಂತ ಹೇಳಿಕೊಳ್ಳಿಕ್ಕೆ ನನಗೆ ಹೆಮ್ಮೆ ಅನ್ನಿಸ್ತಾ ಇದೆ. ಶ್ರೀಮತಿಯವರು 28/10/1972ರಿಂದ ವಕೀಲ ವೃತ್ತಿಯನ್ನ ಶುರು ಮಾಡಿದ್ರು. 8 ವರ್ಷಗಳ ಕಾಲ ವಕೀಲ ವೃತ್ತಿಯಲ್ಲಿ ಯಶಸ್ವಿ ನ್ಯಾಯವಾದಿಯಾಗಿ ಕಾರ್ಯಾಚರಣೆ ಮಾಡಿದ್ರು. 1980ರಲ್ಲಿ ಮುನ್ಸಿಫ್ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ, ರಾಜ್ಯದ ಪ್ರಪ್ರಥಮ ಮಹಿಳಾ ನ್ಯಾಯಾಧೀಶರು ಎಂಬ ಹೆಗ್ಗಳಿಕೆಯನ್ನ ಹೊಂದಿದ್ರು. 1980ರಿಂದ 83ರವರೆಗೆ ಮಂಡ್ಯದಲ್ಲಿ ನ್ಯಾಯಾಧೀಶರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ್ರು. 1983ರಲ್ಲಿ ಡೆಪ್ಯೂಟಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಬೆಂಗಳೂರು ಈ ಹುದ್ದೆಯಲ್ಲಿ ತಮ್ಮ ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸಿದ್ರು. ಅಧೀನ ಕಾರ್ಯದರ್ಶಿ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ವ್ಯವಹಾರಗಳ ಇಲಾಖೆ, ಕರ್ನಾಟಕ ಸರ್ಕಾರ, ವಿಧಾನಸೌಧ ಬೆಂಗಳೂರು ಇಲ್ಲೂ ಕೂಡ ತಮ್ಮ ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸಿದ್ರು. ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಕಾನೂನು ನೆರವು ಮಂಡಳಿಯ ಕಾರ್ಯದಲ್ಲಿ ಕೂಡ ಸಹಯೋಗವನ್ನ ಹೊಂದಿದ್ರು. ನ್ಯಾಯ ದೇಗುಲದಲ್ಲಿ ಮಧ್ಯಸ್ಥಿಕೆ ಕೇಂದ್ರ ಸೇವೆ, ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಈಗಾಗಲೇ ಹೇಳಿದಂತೆ ಸದಸ್ಯರಾಗಿದ್ರು. ಪ್ರಪ್ರಥಮವಾಗಿ ಡೆಸಿಗ್ನೇಟೆಡ್ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಕೂಡ ಆದ್ರೆ ಎರಡನೇವರಾಗಿ. ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಮೊಟ್ಟ ಮೊದಲ ಹಾಗೂ ದೇಶದ 5ನೇ ಹಿರಿಯ ಮಹಿಳಾ ನ್ಯಾಯವಾದಿ ಎಂಬ ಗೌರವಕ್ಕೆ ಕೂಡ. ಶಿಕ್ಷಣ ಕ್ಷೇತ್ರಕ್ಕೆ ಬಂದಾಗ ಶ್ರೀಮತಿಯವರು ಪ್ರತಿಷ್ಠಿತ ಶೇಷಾದ್ರಿಪುರಂ ಶಿಕ್ಷಣ ಟ್ರಸ್ಟ್ ಸಂಸ್ಥೆಯ ಚುನಾಯಿತ ಟ್ರಸ್ಟಿಯಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ್ರು. ಶೇಷಾದ್ರಿಪುರಂ ಲಾ ಕಾಲೇಜಿನ ಚೇರ್ಪರ್ಸನ್ ಕೂಡ ಆಗಿದ್ರು. ಕರ್ನಾಟಕ ಆಡಳಿತ ಮಂಡಳಿ ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್, ಇಲ್ಲಿ ಪ್ರಥಮ ಮಹಿಳಾ ಸದಸ್ಯರು ಎಂಬ ಹೆಗ್ಗಳಿಕೆಯನ್ನು ಹೊಂದಿದ್ರು. ಜನಪ್ರಿಯ ನ್ಯಾಯಾಧೀಶರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿದ್ರು. ಸಮಾಜದ ವಿವಿಧ ಕ್ಷೇತ್ರಗಳಲ್ಲಿ ವಿವಿಧ ಸ್ಥಾನಮಾನ ನಿರ್ವಹಣೆ ಕೂಡ ಸೇವೆ ಮಾಡಿದ್ರು. ಕಾಲೇಜು ದಿನಗಳಿಂದಲೂ ಅಭಿನಯದ ಒಲವು ಇತ್ತು ಶ್ರೀಮತಿ ಮಂಜುಳಾದೇವಿ ಅವರಿಗೆ. ಯೂತ್ ಫೆಸ್ಟಿವಲ್ ಉಲ್ಲಾಳ್ ಶೀಲ್ಡ್ ಸ್ಪರ್ಧೆಯಲ್ಲಿ ಭಾಗಿಯಾಗಿ ಕಾಲೇಜಿಗೆ ಗೌರವ ತಂದುಕೊಟ್ಟಂತ ಹಿರಿಮೆ. 1972ರ ಯೂತ್ ಫೆಸ್ಟಿವಲ್ ಸ್ಪರ್ಧೆಯಲ್ಲಿ ಬೆಸ್ಟ್ ಆಕ್ಟ್ರೆಸ್ ಎಂಬ ಒಂದು ಪ್ರಶಸ್ತಿಯನ್ನು ಕೂಡ ಗಳಿಸಿದ್ರು. ಸುಗಮ ಸಂಗೀತ, ವಚನ ಹಾಗೂ ಜಾನಪದ ಸಾಹಿತ್ಯಗಳಲ್ಲಿ ಒಲವು, ಓದು ಪ್ರಿಯ ಹವ್ಯಾಸ. ನಾವು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ವಿಭಾಗದಲ್ಲಿ ಪ್ರತಿ ವರ್ಷ ಗಣೇಶ ಉತ್ಸವನ ಮಾಡ್ತಾ ಇದ್ರು. ಅಂತ ಸನ್ನಿವೇಶದಲ್ಲಿ ಶ್ರೀಮತಿ ಮಂಜುಳಾದೇವಿ ಅವರು ಹಾಡನ್ನು ನಾನು ಕೇಳಿದ್ದೇನೆ. ಸ್ನೇಹಿತರೆ, ಇಂದು ಕಾರ್ಯೇಶು ಮಂತ್ರಿ ಕರಣೇಶು ಮಂತ್ರಿ ಅಷ್ಟೇ ಉಳ್ಕೊಂಡಿರೋದು. ಉಳಿದ 2 ಅವಮಾನಕರವಾದಂತ ವಾಕ್ಯಗಳು ಏನಿದಾವೆ ಅವನ್ನ ನಾವು ಇವತ್ತು ಕಾಣ್ತಾ ಇಲ್ಲ. ಕಾರ್ಯೇಶು ದಾಸಿ ಅಥವಾ ಶಹನೇಶು ರಂಭ ಈ ಶಬ್ದಗಳಿಗೆ ಇವತ್ತು ಬೆಲೆನೂ ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾವು ಬೆಲೆ ಕೊಡತಕ್ಕಂತ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಇವತ್ತು ಉಳ್ಕೊಂಡಿರೋದು ಕರಣೇಶು ಮಂತ್ರಿ ಅಷ್ಟೇ ಮಾತ್ರ. ಮಹಿಳೆಯನ್ನ ಯಾವ ಸ್ಥಾನಕ್ಕೆ ನ್ಯಾಯಾಧೀಶರು ಕೂಡ ನೋಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ, ಇತ್ತೀಚಿನ ತಮ್ಮ ತೀರ್ಪಿನಲ್ಲಿ ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ ಅವರು ವುಮೆನ್ ಏರ್ಫೋರ್ಸ್ ನಲ್ಲಿ ಆಪರ್ಚುನಿಟಿ ಟು ಬಿ ಗಿವನ್ ಟು ದ ವುಮೆನ್ ಪೈಲಟ್ಸ್ ಆರ್ ದಿ ಆಫೀಸರ್ಸ್ ಅನ್ನು ಕೂಡ ಒಂದು ತೀರ್ಪನ್ನು ನೀಡಿ, ಮಹಿಳೆಯರು ಎಲ್ಲ ರೀತಿಯಲ್ಲೂ ಕೂಡ ವೆದರ್ ಇಟ್ ಇಸ್ ಆರ್ಮಿ, ಡಿಫೆನ್ಸ್ ಆರ್ ಏರ್ಫೋರ್ಸ್ ಎಲ್ಲ ಕ್ಷೇತ್ರಗಳಲ್ಲೂ ಕೂಡ ತಮ್ಮ ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸಿ ಮುಂದಾಳತ್ವವನ್ನು ವಹಿಸ್ತಾ ಇದ್ದಾರೆ. ಇಂಥ ಸನ್ನಿವೇಶದಲ್ಲಿ ಅವರಿಗೆ ಸಂಪೂರ್ಣವಾದಂತ ಒಂದು ಪ್ರೋತ್ಸಾಹ ನೀಡಬೇಕು ಅಂತ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರಾದ ಶ್ರೀ ನಾಗಪ್ರಸನ್ನ ಅವರು ಹೇಳಿದ್ದಾರೆ. ಇಂಥ ಒಂದು ಸುಸಂದರ್ಭದಲ್ಲಿ ಅಂದ್ರೆ ಇಂದಿನ ಮಹಿಳಾ ದಿನಾಚರಣೆಯಲ್ಲಿ ಶ್ರೀಮತಿ ಮಂಜುಳಾದೇವಿಯರನ್ನು ನೆನೆಸಿಕೊಳ್ಳೋದು ನಮ್ಮೆಲ್ಲರ ಆದ್ಯ ಕರ್ತವ್ಯವಾಗಿದೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ KSBC ಲಾ ಅಕಾಡೆಮಿ ಪರವಾಗಿ ಎಲ್ಲ ಮಹಿಳಾ ವಕೀಲರಿಗೂ ಮತ್ತು ಮಹಿಳಾ ವಕೀಲರಿಗೆ ಬೆನ್ನ ಎಲುಬಾಗಿ ನಿಂತಿರ್ತಕ್ಕಂಥ ಅವರ ಪತಿಯವರಿಗೂ ಕೂಡ ಮಹಿಳಾ ದಿನಾಚರಣೆಯ ಹೃತ್ಪೂರ್ವಕವಾದ ಆಶಯಗಳನ್ನು ವ್ಯಕ್ತಪಡಿಸ್ತಾ ಇದ್ದೇನೆ. ಇನ್ನು ನಮ್ಮೊಂದಿಗೆ ಶ್ರೀಮತಿ ಮಂಜುಳಾದೇವಿಯವರ ಪತಿಯವರಾದ ಶ್ರೀ RB ಸದಾಶಿವಪ್ಪ ಅವರಿದ್ದಾರೆ. ಅವರನ್ನ ಈ ಕಾರ್ಯಕ್ರಮದ ಬಗ್ಗೆ ಎರಡು ಮಾತಾಡ್ಬೇಕಂತ ನಾನು ಕೇಳ್ಕೊಂತಾ ಇದ್ದೀನಿ ಸರ್.
ಪ್ಲೀಸ್ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಅವರೇ, ತಾವು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನ ತಾವು ಏರ್ಪಡಿಸಿದಿರಿ, ಅದು ನನಗೆ ತುಂಬಾ ಸಂತೋಷವನ್ನು ಉಂಟು ಮಾಡಿದೆ. ಮತ್ತು ನಮ್ಮ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಅನುರಾಧ ಅವರು ಈ ದಿನ ಲೆಕ್ಚರ್ ಅನ್ನ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಅವರಿಗೆ ನನ್ನ ಹೃತ್ಪೂರ್ವಕವಾದಂತಹ ವಂದನೆಗಳು. ಈ ಸಂದರ್ಭದಲ್ಲಿ ತಾವೆಲ್ಲರೂ ನನ್ನ ದಿವಂಗತ ಪತ್ನಿಯವರನ್ನ ಜ್ಞಾಪಿಸ್ಕೊಳ್ತಾ ಇರೋದು ಅದು ನನ್ನ ಪುಣ್ಯ ಅಂತ ನಾನು ಹೇಳ್ತೇನೆ. ಆದ್ರಿಂದ ತಮಗೆಲ್ಲರೂ ಮತ್ತೊಂದು ಸಾರಿ ತಮಗೆ ವಂದನೆಯನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ನನ್ನ ಈ ಎರಡು ಮಾತುಗಳನ್ನು ಮುಗಿಸ್ತೇನೆ.
ಈಗ ಇಂದಿನ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯಲ್ಲಿ ಇಂದಿನ ಉಪನ್ಯಾಸ ಪ್ರಿಸಂಪ್ಷನ್ಸ್ ಅಂಡರ್ ದಿ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್, ಈ ಬಗ್ಗೆ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಹಾಗೂ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಹಿರಿಯ ನ್ಯಾಯವಾದಿಯಾದ ಶ್ರೀಮತಿ SR ಅನುರಾಧ ಅವರು ಇವತ್ತು ನಮ್ಮೊಂದಿಗಿದ್ದಾರೆ. ಅವರನ್ನ ಈ ಕಾರ್ಯಕ್ರಮ ನಡೆಸಿಕೊಳ್ಬೇಕಂತ ಹೇಳ್ಬಿಟ್ಟು ವಕೀಲರ ಪರಿಷತ್ತಿನ ಪರವಾಗಿ ಮತ್ತು ಲಾ ಅಕಾಡೆಮಿ ಪರವಾಗಿ ನಾನು ಕೇಳ್ಕೊಳ್ತಾ ಇದ್ದೇನೆ. ಓವರ್ ಟು ಯು ಮೇಡಮ್.
ಧನ್ಯವಾದಗಳು ಬಸವರಾಜ್ ಅವರೇ. ಮೊದಲಾಗಿ ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ನಾನು ಎಲ್ರಿಗೂ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನನ್ನ ಮಾತು?
ಎಸ್ ಮೇಡಮ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಇವತ್ತು ವಿಶೇಷ ಕಾರ್ಯಕ್ರಮ ಆಗಿರೋದ್ರಿಂದ ನನ್ನ ಕಡೆಯಿಂದನೂ ಎಲ್ರಿಗೂ ಹೋಳಿ ಹಬ್ಬದ ಶುಭಾಶಯಗಳು ಮತ್ತು ಮಹಿಳಾ ದಿನದನೂ ಶುಭಾಶಯಗಳು. ಮೊಟ್ಟ ಮೊದಲಾಗಿ ನಾನು ಒಂದೆರಡು ಮೇಡಮ್ ಬಗ್ಗೆ ಮಾತಾಡ್ಬೇಕು ಅಂತ ನನ್ಗೆ ಬಹಳ ಇಷ್ಟ. ಇವರ ಒಡನಾಟ ನನ್ ಜೊತೆ ಕೋರ್ಟಿನ ಆವರಣದಲ್ಲೇನೆ ಜಾಸ್ತಿ ಇರ್ತಾ ಇತ್ತು. ಇವರ ಅನಿಸಿಕೆ ಮಹಿಳಾ ಹೋರಾಟಕ್ಕಾಗ್ಲಿ ಅಥವಾ ಮಹಿಳೆಯರ ಬಗ್ಗೆ ಆಗ್ಲಿ ನಮ್ಮಿಬ್ಬರದ್ದು ಒಂದೇ ಇರ್ತಾ ಇತ್ತು. ಏನು ಅಂತಂದ್ರೆ, ನಾನು ಧೈರ್ಯದಿಂದ ಮತ್ತು ಹೆಮ್ಮೆಯಿಂದ ಒಬ್ಬ ಸ್ತ್ರೀವಾದಿ ಅಂತ ಹೇಳ್ಕೊಳಕ್ ಇಷ್ಟಪಡ್ತೀನಿ. ಹಾಗೆಯೇ ಪುರುಷ ದ್ವೇಷಿ ಅಲ್ಲ ಅನ್ನುವಂತ ತತ್ವ ಮಂಜುಳಾದೇವಿ ಅವ್ರದ್ದು ಇತ್ತು. ಇದು ನನಗೆ ಬಹಳ ಇಷ್ಟ ಆಗ್ತಾ ಇತ್ತು. ಯಾವಾಗ್ಲೂ ಜನರಿಗೆ, ಅದರಲ್ಲಿ ಹೆಣ್ಮಕ್ಳಿಗೆ ಸಹಾಯ ಮಾಡ್ಬೇಕು ಅಂತ ಯಾವಾಗ್ಲೂ ಮುಂದ್ ಬರೋರು. ಅವ್ರ ಜೊತೆ ಯಾವಾಗ್ಲೂ ಒಂದ್ 5-6 ಜನ ಹೆಣ್ಮಕ್ಳು ಓಡಾಡ್ಬೇಕು, ಅಡ್ವೊಕೇಟ್ಸ್, ಜೂನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಸ್. ಯಾರಾದ್ರೂ ಕಾಣಿಸ್ದೇ ಇರುವಾಗ ನಾನು ಕೇಳ್ಬೇಕು ಅವ್ರಿಗೆ, ಏನ್ ಮೇಡಮ್ ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ ಅಂತ. ಅವ್ರು ನಂಗೆ ಹೇಳ್ಬೇಕು, ಅನುರಾಧ, ಹೆಣ್ಮಕ್ಳ ಕಷ್ಟ ನಿಂಗೆ ಗೊತ್ತಿಲ್ಲ, ಎಷ್ಟೋ ಕಷ್ಟಪಟ್ಟು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಅವ್ರಿಗೆ ಯಾವಾಗ್ಲೂ ನಾವು ಬೆಂಬಲಿಸ್ತಾ ಇರ್ಬೇಕು ಅಂತ. ಅವಾಗ ನಂಗೆ ಅಷ್ಟೊಂದಿದ್ರ ಅರಿವು ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ. ಆದ್ರೆ ಕ್ರಮೇಣ ಎಷ್ಟು ಕಷ್ಟ ಇದೆ ನಮ್ಮ ವೃತ್ತಿನಲ್ಲಿ ಮಹಿಳೆಯರಿಗೆ ಅನ್ನೋದು ಅದರ ಅರಿವಾಯ್ತು. ಅವರ ಮುಖದಲ್ಲಿ ನಾನು ಯಾವತ್ತೂ ದ್ವೇಷ, ಅಸುವೆ ಅಥವಾ ಒಂದು ಕೋಪ ಕಂಡಿದ್ದೇ ಇಲ್ಲ. ಹಸನ್ಮುಖಿ, ಯಾವಾಗ್ಲೂ ನಗ್ನಗ್ತಾನೆ ಇರೋರು. ಇವರ ಒಂದು ವ್ಯಕ್ತಿತ್ವ ಮತ್ತು ನಮ್ಮ ಮಹಿಳೆಯರ ವ್ಯಕ್ತಿತ್ವವನ್ನು ನಾನು ನೋಡಿದಾಗ ನನ್ಗೊಂದು ಕಗ್ಗ ನಾಪಕ ಬರ್ತಾ ಇದೆ. ಆ ಕಗ್ಗ ಹೀಗೆ ಹೋಗುತ್ತೆ: ಘನತತ್ವ ಒಂದಕ್ಕೆ ದಿನರಾತ್ರಿ ಮನಸೋತು, ನೆನೆಯದು ಮನವು ಇನ್ನೊಂದನು, ಎಲ್ಲವನ್ನು ನೀಗುತ್ತ ಅದರ ಅನುಸಂಧಿಯಲ್ಲಿ ಜೀವ ಭಾರವ ಮರೆಯುವುದು ಹನುಮಂತನ ಉಪದೇಶ ಮಂಕುತಿಮ್ಮ. ಒಂದು ಘನತೆಗೋಸ್ಕರ ಎಷ್ಟೆಲ್ಲ ನಾವು ಕಳ್ಕೊಬೇಕಾಗತ್ತೆ, ತ್ಯಾಗಗಳನ್ನ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಅದರಲ್ಲೂ ಹೆಣ್ಮಕ್ಳು ಹೆಚ್ಚಾಗಿ ತ್ಯಾಗ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅಂತ ನನ್ನ ಇದು ವೈಯಕ್ತಿಕ ಅಭಿಪ್ರಾಯ. ಅನ್ಯತಾ ದಯವಿಟ್ಟು ಯಾರು ಭಾವಿಸಬಾರ್ದು. ಆದ್ರೆ ಇದೇ ವೃತ್ತಿ ನಮಗೆ ಎಷ್ಟೊಂದು ಕೊಟ್ಟಿದೆ. ನಾವು ಒಂದು ಒಳ್ಳೆ ವಾದ ಮಾಡಿದಾಗ ಅಥವಾ ನಮ್ಮ ಒಂದು ಕೇಸಿಗೆ ಒಂದು ರಿಸರ್ಚ್ ಮಾಡಿ ಒಳ್ಳೆ ತಿರುವನ್ನು ತಂದು ಕೊಟ್ಟಾಗ ಅದು ಸಿಕ್ಕದಂತ ಸಂತೋಷ ಇನ್ನೆಲ್ಲೂ ಸಿಗೋದಿಲ್ಲ. ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಅದರ ಅನುಸಂಧಿಯಲ್ಲಿ ಜೀವ ಭಾರವ ಮರೆಯುವುದು ಹನುಮಂತನ ಉಪದೇಶ ಅಂತ. ಸೊ ಈ ಕಗ್ಗದೊಂದಿಗೆ ಇವತ್ತಿನ ವಿಷಯಕ್ಕೆ ಹೋಗಕ್ಕೆ ನಿಮ್ಮೆಲ್ಲರ ಅಪ್ಪಣೆಯನ್ನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. Today's topic I have chosen presumptions under Evidence Act. I am going to give a talk for about, let's say about 40 minutes, depending on how much time we have. We've already started late. And most of these sections, which are there about 18 shall presumes and about 8 may presume, and 2 conclusive proofs. Each one of these sections is a topic by its own. So I must at this point thank the Academy and the chairman and their members for making me read into all of these, which I don't think in a normal course I would have done it. I thoroughly enjoyed doing that. And but since it's such an elaborate subject, if you will sit with me all through, then you will know why I chose this subject, this topic, and what is interesting about this. I have made a small PPT for all of you. And I must also share with the chairman that we've got the maximum attendance today. And I think that credit should go to our senior Srimati Manjuladevi. I have made a small PPT for you. And if the host can just allow me to co-host for today, and then I can share that PPT. Baswaraj, are you there?
I'll make you admin. Okay, you're the host now. Kindly unmute yourself.
Yeah, now am I right? Oh, fine. Okay,
Yes.
so we are all what shall I say, slaves of this technology, and we are completely dependent on them. So if internet goes, then we are all disconnected. But we will try and do the best in this session today. So this, okay. Yes. So as you all can see, the Evidence Act is a pre-independence act. It's of 1872. And if I were to speak about presumption, the act does not define what presumption is. Then what do we understand presumption to be? ಸರಳವಾಗಿ ನಮ್ಮ ಭಾಷೆಯಲ್ಲಿ ಹೇಳಬೇಕು ಅಂದ್ರೆ ಊಹಿಸ್ಕೊಳ್ಳೋದು ಅಂತ. ಯಾವ್ದಿರಲ್ವೋ ಅದನ್ನು ಊಹಿಸ್ಕೊಳ್ಳೋದು. Now, if I were to show you what the dictionary says, so it says a legal inference as to the existence or truth of a fact not certainly known, or it can be an inference that is drawn from a known or a proved existence. If I can give you an example, there is no scientific evidence that a PPT presentation will have more audience than a regular audio presentation. But still we presume that when there's a PPT presentation, people are more impressed. Now, this possibly is based on the fact that am I audible? Hello? Can you hear me?
Yeah, we can hear it.
Okay, thank you so much. So that is the nature of presumptions. It is completely based on one fact. If that is proved, then the logical conclusion of it. Let me give you another example. Today we have about, in Karnataka, we have about 120 IAS officers. If I am not clear, if I'm not certain on the number, so kindly pardon me, but generally about 120 IAS officers, and we are about 5 to 7 women IAS officers. Now, if there is going to be any situation between 2 or 3 men, it'll never make a news. But if there's going to be a situation between 2 women, then we presume that one woman is the worst enemy of another. So like this, presumptions in life we keep making based on certain facts, and it also depends on how each one understands their life or their mind realizes to certain situations. But in law, it is not like that. We have to keep in mind that in law, there are certain presumptions which are given under the Act, and it is only those presumptions that need to be taken into consideration while we are conducting our cases. So before we go into which are those presumptions and how does a presumption work, we also need to keep in mind that there is a difference between a legal fiction as against a presumption. In law, if there's a legal fiction which is already in existence, whether it's fact or not, for example, a person who is 7 years and younger cannot commit crime. This is a legal fiction, and the courts have to abide by this. But under a presumption, it will certainly depend on the satisfaction of certain circumstances. So the Act under Section 4 gives 3 kinds of presumptions. So we have 2 types of presumptions which are not mentioned in the Evidence Act, but these 3 kinds of presumptions, that is, may presume, shall presume, and conclusive proof. This is under Section 4 of the Evidence Act. May presume and shall presume are rebuttable presumptions, whereas conclusive proof is a irrebuttable presumptions. Now, what does these each may, shall, and conclusive proof mean? I've just put down what the section actually says. Reading would be time consuming, so you can see it for yourself. When the court needs to may presume, when the city section provides may presume, then the court may presume, but it is subject to the rebutting of the same presumption. So we'll go under each section slowly. If you see in shall presume, there is a direction to the court to say if under the Act it is directed that a particular fact will be presumed, then the court shall presume such a particular fact. The conclusive proof is a situation where the court is required to take it as conclusive, unless and until the very section, if it provides any way to get it over, and if that getting over happens by the other side, then the court can give away or get over the conclusive proof. Otherwise, the section declares that for a conclusive proof, it has to be followed by the court. Now, these are the certain sections. I'm just going to run through them. So presumption, section 79, these are all shall presumptions. So let's do shall presumptions first. They are more large in number. Presumption as to genuineness of certified copies. So there are conditions for it. It should be declared by law to be admissible. So in every certified copies, however it is to be declared, like I'll give you an example. We have to give our degree certificate or our marks cards to various authorities. At that point of time, the authority which is prescribed, who can certify such a copy, only if that authority certifies it, then it becomes a certified copy. If it is a court order, for example, then how a court order requires to be certified will be given in some rules. So only when that officer certifies it, then it becomes a certified copy. So that's the essence of presumption as to genuineness of certified copies. Section 80 speaks about presumption to documents produced as record of evidence. So when you have a witness who's giving a statement, or when there are confession statements, so the law requires that whatever is the procedure that is given, if the evidence is made following that prescribed procedure, then such a fact or evidence becomes a shall presume, and the court is duty bound to presume such a fact or evidence. Then you have section 81, presumption as to gazette newspapers, private acts of parliaments, and other documents. So here you have to keep in mind that newspaper reporting is not an admissible evidence. That is one of the exceptions, though the word newspaper is used in the section, unless the person who is the editor or the person who's published it comes, appears, and deposes to that effect, then newspapers cannot be. That's why when people who practice in High Court in writ petitions, we many times put newspapers. So these cannot be authenticated, and because in writ petitions we do not take evidence of persons who can give evidence to that. So that is why in writ petitions newspapers are not evidence value. There is a case law for that which speaks about it. So I put it down. If anyone interested, you can please take it down. Then 81A, this was a most of the electronic sections that you can see here were all brought after our Information and Technology Act, which came in 2000. Suitable amendments were made for Evidence Act. So the very same thing, that is gazettes and other documents, if it is in electronic form, then they also shall be presumed. Now, all government maps shall be presumed as genuine and authenticated if they are given by the state government or central government. So when you see that if there is any sketch or map given of your property by a government authority, that will have a better evidentiary value than a map made by someone else. That also is there in May presumption. I'll come to that. Then you have section 84, Presumptions Act to Collection of Laws and Reports of Decisions. When you are relying upon any other reporting decision of any other country, then if that reported decision is published by the local government of that country, then such a reporting will be accepted here. This is what section 84 says. Then you have presumptions as to power of attorneys. Now, each power of attorney is different than the other. So as and when it is to be executed, authenticated, depending on the rules, only if it is done in that manner, then that presumption will play. Then you have then the very same power of attorney comes in electronic forms, that is electronic agreements, signatures for that, and digital signatures are also treated as presumptive value under section 85 A, B, and C. Okay, I think. So next you have section 89, presumptions as to due execution, etc. of documents which are not produced. What does this mean? This means when the court calls upon the other side to produce certain documents, many times the lease agreements will not be in the hands of a lessor. It will be generally in the hands of the lessee. And if the court calls upon the lessee to produce and the lessee does not produce, then the court can presume that such a document was in existence. Then you have section 111A, presumption as to certain offenses. This is very interesting. When I was not aware of it, and it was an interesting read. So let's assume in a given state is under some kind of a disturbance, or it's under war, or it is local disturbances happening. And if anyone is alleged for certain offenses like possession of arms or causing disturbances, then the court can presume that during that time such a person was guilty of that offense. Then you have section 113, which is presumption as to dowry death. I'll deal with this a little later. Now I'm going to go to May presumptions. There are just about 8 sections. The headings are very, very self-explanatory, so we don't need to go much into it. Presumptions as to certified copies of foreign judicial records. Then you have presumptions as to books, maps, and charts. So make a distinction between section 88 and section 87. Sorry, section 83. Section 83 was where maps and sketches given by the government. Here, these are books and charts. We had an interesting case where we relied upon a book written by V.K. Menon, our first defense minister, about accession of different states. And we had a property dispute where we were relying upon the accession and the private treaties between the King of Mysore with the government of India. So at that time, we took a help of a book to show that such a understanding did exist between the king and the government of India. So that was one example that I could give. Then 88 is presumption as to telegraphic messages. So any telegraphic message which is given through a source. So generally in India, we don't have to worry because we have only one government-owned telegraph system. Now we have made electronic messages. So this you'll have to be careful to see that these presumption as to electronic messages in IT Act. For example, emails, then WhatsApp. What is the authentic value of these? So it changes from person to person and the medium of electronic medium that the person has used. If it's an email, the person who has originated the mail, he needs to give a certificate under the IT Act. that was a computer or a system which the person owned, and from that it was transmitted or email was written. Then you have presumption as to document 30 years old. Any 30-year-old document produced before the court for proper custody shall be presumed, may be presumed as genuine. Then the same thing applies if it's a 5-year-old document. Again, we need to keep in mind, friends, that these are only may presumptions. And I will also show you what's the distinction between a may presumption and a shall presumption. So section 113A, presumption as to abatement of suicide by a married woman. Section 114 is very important. It has presumption of certain facts. Each one will run through quickly. Unaccounted possession of stolen goods. Let's assume there is a theft and A is caught with the stolen goods. Unless then the burden shifts to A, he needs to show that this was not stolen goods and he has to show the source of those goods. Then unworthiness of an accomplice. If there is an accomplice to a crime, his evidence is not to be relied upon. Then endorsement of a bill of exchange. Like if you sign a check, then it's a presumption that such a check was validly executed. Then endorsement of, state of things ceases to exist before its natural time. So the book says that if there is any river which is taking a regular path, and let us assume because of floods it has changed its path, the court will presume that the original path was also in existence. If I can give you any other example, let's say there is a go down holding lot of food grains, and the life of food grains could be a year or year and a half. But if it is perished before that for quantification of damage or etc., the court can presume that it could have stayed for 1.5 years or 2 years, which is the lifetime of that particular things or particular time. Then you have judicial and official acts which are regularly performed. These acts should be performed in their normal course and as required under the respective acts. Then the presumption will come. Then common course of business, like under the Companies Act or any company which is doing any business in its common course. So if it is able to show that it was in my common course that I acted in this particular manner, then such a presumption will come into play. Then evidence unfavorable to the person who withholds it. This we also similar section we saw earlier. If there's an evidence which is in my favor and I am withholding it, then the court can presume adverse to that information which I'm withholding. Then again, same thing applies to refusal to answer a question. If in witness box, if a witness refuses to answer a question, the court can presume otherwise. Then document creating obligation in the hands of the obliger. Then the obligation is said to have been discharged. Now, these are by and large that I wanted to show you in may and shall presume. That is what the Act prescribes. Now, kindly see the distinction. In a may presume, the court has a discretion to accept that presumption. And it has to be heavily rebutted, and onus of the proof clearly shifts and completely affects the onus of burden of proof on the plaintiff and shifts to the defendant. But in case of a shall presumption, if that presumption is being put forth by following the prescribed rules that have been given under that, then the court is bound to accept that. And only if it is rebutted by the other side, then that presumption will pale into insignificance. But if it is no rebuttal and a shall presumption is there and the party has made shall presumption, then the verdict must come in favor of the presumption, is what is held in AAR 1979, Supreme Court 1848. So this is the rebuttable presumptions too. That is, let me sum up on this. Rebuttable presumptions, there are two. One is may presumption and shall presume. What are the distinction? I've given you slightly. So you can see there, if there is a shall presume provision and you have discharged that, and if it is not rebutted sufficiently, then the court is required to give a judgment in your favor. Now we have two only conclusive proof sections under the Evidence Act. One is birth of a child during marriage. That means a conclusive proof of its legitimacy, unless non-access is shown. Then section 113 is proof of cessation of territory. So if there's an official gazette given by the government of India that this is what is acceded to the government of India or to a particular state, then that will be the conclusive proof of such cessation or accession. Now, this is by and large the cursory reading of the various sections under the Evidence Act, which speaks about presumptions. As I told you, that I would like to concentrate on these 4 sections, which is quite relevant for today's day. 112, 113A, 113B, and 114. These are relating to women. These are the common link between all these sections. One could argue to say 112 is not so much to do with women, it is to do with the child and protection of the child. I completely accept that. But as I elaborate that section, you will also see that it is indirectly concerning the women as well. Let's see 113A. First of all, it's a may presume. It's a death by suicide. This was a section which were rather amended after we had the Dowry Prohibition Act in 1984. So this section has come in 1986, if I'm right. There are 2 essential requirements for this presumption to play. One is within 7 years of the marriage, if there is any death of the woman, then it is to be presumed that it was a dowry, death due to dowry or death due to cruelty. So let me rephrase this. Whenever there is a woman who commits suicide, that is death by suicide, and if the suicide is within 7 years of her marriage, and if the prosecution is able to show that she died because of some cruelty that is inflicted on her, then the court can presume that it is the person who inflicted the cruelty abated her suicide. Now, cruelty here, this act doesn't define. It's the same as 498A of IPC, where cruelty has been defined. Now, these are the few case laws. No doubt in the Sushil Kumar Sharma, the constitutional validity of 113 was not tested. It was only tested, it only tested 498A of IPC, which speaks about punishment for cruelty, as cruelty making cruelty as an offense. The court held that this is a beneficial legislation and therefore it is valid. We can discuss this a little later thereafter. I'm sure many things are going in many people's mind. Then what is the meaning of cruelty was explained for the first time in Arvind Singh versus State of Bihar. You can see that. And mental cruelty was also included as cruelty. So 113A, if there is a suicide of a woman, if those 2 conditions are met, then the person against whom the allegation is made, it should be presumed that that person abated the suicide of that lady. Then you have 113B. 113B is a death of a woman, that is killing of a woman because of dowry demand, cruelty or harassment. Then in such cases, it shall be presumed that there was a murder of that person. Now, if you can see the difference between 113A and 13B, 113A speaks about suicide of a woman, abatement to suicide, where she kills herself. 113B is murdering of a person. So if there is killing of a woman, when soon before that, if she has been harassed or there is a cruelty inflicted on her, then it can be presumed that she was murdered for these offenses, that is dowry or cruelty or harassment. Now, the word soon before is the critical word here. And in this 2004 Supreme Court, the Apex Court has said that what is the meaning of soon before? Can it be like 1 month? Should it be 3 months? Should it be how much? What is the time period? For that, the Supreme Court says that there should be a link between existence of proximity between the time that the death happens and the actual cruelty, the effect of cruelty that has taken place. So this is insofar as these two sections. I've given you a distinction between both of them, which is quite self-explanatory, and I also explained to you a minute ago. So I'm now going to run through this slide, and you can see the difference between the two. Now, 114A, this is a very important presumption. Whenever there is any rape, for example, and if the question is whether the rape was or the intercourse was with the consent of the lady or not, and if the lady gives an evidence that it was not with her consent, then the court shall presume that it was not with her consent, and the burden will shift onto the other side to show that it was with her consent. So her evidence is sufficient. Now this applies to all the provisions of sections 376 to A to N as well. And you can also see an amendment in Chhattisgarh where this presumption is extended to any sexual harassment, outraging modesty of women, stalking, intrusion of privacy. All this also is included. Now, this is one more section. Next, we'll go to this. Section 112, birth of a child in a valid marriage or 280 days after the separation, then it's conclusive proof of the legitimacy of that child. So two essential ingredients. If somebody were to show that there was a valid marriage subsisting, now what is valid marriage? You'll have to go under the Hindu Marriage Act or any marriage act to say what is a valid marriage. And during that valid marriage, if there is a child which is born, then it shall be a conclusive proof. So as I said, there are only two conclusive proofs under the act. One is this, and another is issuings of official gazette for accession of any land by the government. Apart from these two, there are no other conclusive proof under the section, under the Evidence Act. So this has been spoken about quite a bit. We'll see what is the requirements and how this presumption can be gotten over. The only way that this presumption can be ignored is if the person who is disputing the legitimacy of the child or the husband is able to show that there was no excess between the two of them. So the word non-excess has been the subject matter of interpretation in various decisions. I was also surprised to see that first time it was interpreted in the year 1934. What is the meaning of the word access? So it says, connotes existence of opportunity for marital intercourse. Like if the husband and wife are living under the same roof, the court will presume that they did have an opportunity. And if a child is begotten, then the child is legitimate. In 1954, also we have, so the 1934 is a Privy Council decision, and which is also adopted by our Supreme Court in 1954. Now, where do we now with the, this is a section which came in the year 1872. Now, it's almost like 100 and so many years, and things have changed. It is now being argued, it is possible that we may be living under the same roof, but there could not have been intercourse between us. So can that be seen as non-excess? Absence of intercourse between a husband and wife, can it be shown to be non-excess, was also a part of interpretation. And the court in 2009 said that presumption cannot be displaced by mere balance of probabilities or any circumstances of cheating doubt. So up to 2009, this is how the law worked. Now let's see in 2001. Slowly people started producing scientific evidence. Earlier it used to be blood tests, then it became DNA testing. Couples, rather husbands, started arguing in the court that though we lived under the same roof, there was no access or an opportunity for us to have intercourse. And for that, I am going to show a DNA testing. So in 2001, the Supreme Court said the result of a genuine DNA test is said to be scientifically accurate, but even that is not enough to escape from the conclusiveness of Section 112 of the Evidence Act. Children should not suffer social disability on account of laches and lapses of the parents. Now, after this decision, there was an interesting decision that has come out from the Kerala High Court, where they have said that we are not going to rely upon the DNA testing, but we are going to interpret the word access to mean the access of the sperm to the ovum. And if on oral evidence or otherwise, we are going to have some sufficient evidence to say that there was absence of intercourse between the two, even though they had an opportunity by staying under the same roof, then also we can say that the non-access was proved. And in that case, this is how the Kerala High Court has held. I don't think this has gone beyond, but what is interesting is what the Supreme Court has said thereafter. So in all these three cases, especially Dipanvita Roy and Nandalal, the issue was not Section 112 at all. This is where I told you why 112 is related to women as well. The husbands took a contention that the wife was in an adulterous relationship. And in order to prove the adultery, they wanted to show that the child which was born in the marriage was not that of the husband. And if it is proved that it is not that of the husband, then adultery is proved and they were asking for divorce. So parties did not say that this is not my legitimate child. The husbands did not say that. It was in another way this happened. Now, after these, and of course, the court accepted on the facts of that case that the woman could have been in an adulterous relationship, but they said since Section 112 presumption is not in question here, we are not going to give any decision or finding on that issue. So the children were legitimate, but the adultery of the woman was accepted in this case. Now, this is a recent case which has come about on 20th February 2023. This is a decision given by Justice B.V. Nagaratna of our High Court, who's now in the Supreme Court. Now, people started using DNA testing to show that the wife was in an adulterous relationship. This is also one such case. And in this, a complete, what shall I say, a summary has been made, and it's very interesting read. It says non-access is a must to dislodge 112 presumption. So they're protecting the child here. Then DNA test where paternity of the child. I just lost this. I think we lost screen sharing, I think. Are you able to see the screen share?
1 second, only 1 second. I wanted to mute someone who was creating the problem. One minute.
Okay, no worries.
I'll make you admin again. Yes.
I'm going to do that.
Yes. You're the host now.
Yeah. Now my cursor is gone. Okay, I'm unable to do the screen sharing now for some reason. My cursor is not working. Yeah, as I said, we are all victims. So we will, I'll just complete where I was. So I was at 112. Now that was an interesting decision on February 20th, 2023. The courts have cautioned that in order to prove the adulteress of the woman, you need not have to show the paternity of the child. If there are other evidence that you can prove, that is what you should exhaust first and not seek to this means of disturbing the mind of the child and the family as a whole, is what in this decision, Justice Nagaratna has very elaborately said that. Now, I would be failing in my duty if I do not refer to the decision of Justice Ravindra Bhatt in the famous Rohit Shekhar versus and in that view, the judge held and brought about a distinction between paternity and legitimacy. So it said it could be possible that the child's paternity could be with someone else, but the legitimacy always will be within the valid marriage. There have been criticisms on this, but I can say in favor of it is when you adopt a child, the paternity of the child will be somebody else's, but then the child becomes your own legitimate couple child. When you adopt surrogacy, when you adopt many other things like this, that time the paternity will be certainly different. So section 112 speaks about legitimacy, and now it is said can't be used to find out the adultery relationship of the wife or to prove the adultery of the wife. Now, by and large, what I wanted to show or share with you with regard to these 4 sections, I think I have done. But in the changing in times where there is a moral degradation of morals in the society, not really attributed to one particular gender, but generally, where are we standing on all these things? People are complaining that there are more and more 498 cases, false 498 cases. There are more and more adultery happening in the society. Where are we then? How are we? These presumptions are so much favorable to women. Where do we men stand? Is by and large, for that, I just want to give you only some statistics. Now, this is statistics. It's from the National Record of Crimes. 2020, I have seen. There were, this was 2020, under 498A. There were more 1,15,049 cases all over. And it was found that 5,520 cases were false. Now, for 2021-22, we are seeing 6,51,406 cases, out of which 16% were shown to be that the parties had some civil disputes, but 1498 was used, and 5% was almost like false cases. So when there is 5% of misuse, then how do we relook this provisions is for us to reflect. Dowry deaths, the maximum are still happening, and I think Karnataka is the 4th highest state for dowry deaths in the whole country. And in order to tweak these provisions and these presumptions, the Supreme Court in 2 cases, one is Arnesh Kumar versus State of Bihar, I'll give the citation, and one is Rakesh Sharma, has ordered for giving a better family welfare approach. They have ordered for constitution of a family welfare committee. So they will, the case will be referred to the family welfare committee, and then the family welfare committee will look into this. And then arrest of, even for family disputes and domestic violence and 498 cases also guidelines have been issued by Supreme Court. So whether we are reached at a place where these laws are completely misused, I leave it to the discretion of the viewers to decide that. But for now, all I can say in the present circumstances is that we have a long way to go before we need to have a strong relook at any of these cases. With this, I think most of the presumptions that I wanted to share with you all, I have done. And the Evidence Act is like it was such a lovely opportunity, because the Evidence Act is like a bridge between the CPC and the IPC. So it's like the main Veda. And both for a criminal advocate and for a civil advocate, Evidence Act becomes extremely important. And presumptions to get over or prove your point or show your evidence is one of the tools that the Act has provided for under the Evidence Act. Now, the only thing I think is left to me to say is that these sections need not be looked with a red eye. And every day we are getting like 200 to 300 calls under the domestic violence in the Mahila Sahayavani that are here. This is not like a blame game from one person to another. Society is in this situation. Whether these presumptions are playing a role, they are playing a role in safeguarding the rights and liberties of women in general. And this may have some kind of a repercussion on the other sex. Well, this is case-to-case basis, courts will look into it. And just for those small percentage, whether we need to get away from them, from these, I think is, I leave it to the wisdom of the audience that are here with me. But for now, I would only want to end by saying that women do have come a long way, and today we had this opportunity where we did speak about a woman, and it was a lovely opportunity for me. And generally, women are looked at to be mixture of sugar and spice, and then we are always told that we are everything that is nice. But I think today women are becoming Wonder Woman. We are challenging norms, we are breaking barriers, we are showing a lot of resilience. And women are always been bold, strong, resolute, charismatic, confident trailblazers, and womenhood needs to be celebrated. On this note, wishing you all another happy Women's Day. I end my talk. Thank you so much.
That was a very difficult subject. Slightly, people to create such an interest in the audience and to explain the intricacies of the Evidence Act was not easy. So I observed your speech on the subject fraternity under the Indian Constitution, the preamble to the Constitution of India. Most of us wouldn't even know about the term fraternity, but the way you explained in the, I think that is Central University Law College lecture, that was magnificent. I always note that you choose a very difficult subject and then make it very interesting. On the Women's Day celebration, I want to say something. I wrote an article in the year 2016. Let me read out the article because it should reach the powers that be at large. I wrote this, that another Women's Day is here. From the legal perspective, it is highly disappointing. The women lawyers are completely ignored in the matter of elevation as High Court judges or other constitutional officers. We have never heard of a single woman advocate general in the country. I think, please correct me if I am wrong. There hasn't been a single advocate general in the country. Even the ongoing selection of the High Court judges of Karnataka does not have a single woman candidate. This was in 2016, and even in the recent batch, the only woman candidate, I think the Supreme Court did not approve. The Supreme Court Collegium did not approve it. Many women lawyers who consent was obtained felt it embarrassing to meet the Collegium judges to pursue their appointment. This is a very disappointing and embarrassing scenario. Give me 1 second. Flip side of the coin is even the honorable judges are stuck in a catch-22 situation. If a particular judge takes extra interest to suggest or recommend or push the candidature of a woman lawyer, it would be looked with suspicion. Only 1 second, there is some problem. Yes. The resulting position is the women lawyers are deprived of the high constitutional positions. Moreover, out of more than 125 senior advocates in the Karnataka, there are very few senior advocates. The procedure provides for inviting the lawyers to be designated as senior advocates. It is surprising to know that not a single woman lawyer has ever been invited by the High Court to be designated as a senior counsel. Many women lawyers say that they have to run to the chambers of the judge to get recognized. No self-respecting woman would ever do that. Unfortunately, this is not done in many high courts of invitation. Therefore, I said the women judges should take up their cause. They should recognize the young, talented women lawyers and promote them for high constitutional offices. This I said in 2014, and the position remains the same. Therefore, I can only reiterate that the women judges should take up the cause and to encourage the young ladies to be adorning the constitutional posts. Now, if there are any questions, you can ask. Only 1 second. There is some. Yes. Madam Anuradha, this recent judgment of the Supreme Court in Ankita, Florida versus Anjing, Florida, that slight, I heard some criticisms on the blog that when a woman refuses a DNA test in respect of her child, she is not only justified, number one, and the second one is the presumption cannot be drawn about the child. Therefore, somewhere down the line, the woman can justifiably refuse the DNA test, and still the courts are not in a position to draw the presumption. So I just wanted to know your view on this. Only 1 second. You can unmute yourself. You can unmute now.
Whether your question, if I've understood right, are you saying that the woman does have a right to deny DNA testing?
Of course,
Of
that part, nobody can dispute that. Nobody can dispute that part. The second one is, even without any valid reasons, if the woman refuses, for example, assume for a moment that the man was out of country for 3 years and he comes back 1 year and he comes back to see that wife is pregnant and he applies for DNA test. The wife can refuse a DNA test and still the court cannot take presumption, cannot raise presumption on the illegitimate or legitimate aspect of the child. That's what the Supreme Court says in Ankita, Florida. So I just wanted to know how far.
No, I don't think that is what it says. See, in the example that you're giving,
Yes.
If the husband is away at the time when the child is begotten, he was not even there. See, we have to keep in mind that this was a section that was brought or put into Evidence Act in 1872. At the time when the British India, the officers would come and go, and they may not be here for a very long time. So in such times, what happens? So if I am able to show that for 1 whole year I was not here, I was in the United States of America, or I was somewhere, or other the husband was somewhere, then he need not go to the DNA testing at all. The section itself has a mechanism in it. If his non-access is able to be shown, then what in this Florida case, what is happening nowadays is the husbands are asking for DNA testing to show that the woman was in an adulterous relationship. Like if the child's DNA test is not comes out that he's not the father, then that is sufficient evidence to show that she was in an adulterous relationship. But the backlash of this was, it was affecting 112, and that is where this judgment has come into existence to say that you cannot take DNA testing of a child for every flimsy ground. If you want to show adultery, there are many ways to show. You need not affect the child's rights to show the adulterousness of the woman. I think that is what this judgment
Paragraph
says.
26 and 28. The Supreme Court says you cannot raise adverse inference under 114H if the wife denies or refuses to undergo the DNA test. That is not to show, you are absolutely right, that is not to show the illegitimacy, that is to show the adulterous. All
these cases was on adultery.
Yes.
Only Kanti Devi was on 112. After Kanti Devi, where Supreme Court has taken a conservative view, and then it was explained away by Justice Ravindra Bhatt to say legitimacy is different than paternity. The child needs to be recognized as legitimate. Maybe the father of the child could be somebody else.
Okay. Now, para 29. Therefore, section 114H has no application to a case where a mother refuses to make the child undergo DNA test. It is remembered that the object of conducting DNA test on the child is primarily to show that the respondent was not the biological father. Once the fact is established, it merely follows a corollary that the appellant was living in an adulterous relationship. Therefore,
Yeah, so that corollary you cannot use to do this is what this
no, there
decision
are
says. Actually,
two
the
judicially
decision-
there are two judicially evolved presumptions. One is the doctrine of last grant of 1955, that somebody is in possession of the property for a very long time, about 200 years, but the title is not traceable. Then the Supreme Court has evolved that the doctrine of last grant applies, and he can contend that that possessory title for a maybe 100 or 200 years will metamorphose into title. That is one. And second one is the recently evolved principle that if a man and woman are living together for a very long time and cohabitation and all that, then it can be safely considered as a marriage,
or presume that they were.
and the children born from such a relationship will be considered as legitimate. So I'll throw open the question and answer session. So the audience can ask the questions if you have 1 minute.
I hope I'm not.
Don't worry. You can unmute yourself and you can ask the questions to the learned speaker. Any questions on this topic?
Madam.
I'm saved.
Hello,
Yes.
madam.
Either they understood completely or they didn't
No,
understand.
it was exhaustive. It was exhaustive.
Madam, one question, madam.
Heli sir.
The admissibility of the confession made before the police, madam.
Yes, sir. Heli.
Adra ಬಗ್ಗೆ ಹೇಳಿ madam ಸ್ವಲ್ಪ.
See, I gave you the section under which evidence confession. See, admissibility of evidence before the police does not come in that presumption section that I told you. Let's see which is that particular section.
27?
Illa, ಹೇಳ್ತೀನಿ ರೀ.
Statement.
Record of evidence. See, 80 only speaks about witness evidence in court, marking of documents, and statement of confessions. So not a confession before police. So that is not included in section 80, sir. So presumption baralla adralli. Statement given before police comes under CRPC, but under 80 that is not included. There's no presumption to be taken that it was valid. It was that statement was correct before the police, because statement given before the police is not there. See, we have to keep in mind, Evidence Act is by and large proving of evidence before a court of law, and I would stand corrected otherwise, but it is evidence before court of law, and it has nothing to do with other functionary authorities like police or anyone else. I hope, sir, that answers your question.
Thank you, madam.
Madam.
Heli, madam.
Madam, happy Women's Day.
Thank you, madam.
And I thank Basavaraj sir, Sadashiva sir, and madam for getting this knowledge lecture. And madam, Arnesh Kumar judgment ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರ, you could not post it because you could not.
I know this one is gone. Nodi,
Yes.
I will share it. Only those two decisions, the latest one. 2018-19 allo.
ಅಂದ್ರೆ ಕೋರ್ಟ್ ಅಲ್ಲೂ ನಾವು ಕೇಳಿಸ್ಕೊಳ್ತಾ ಇರ್ತೇವೆ, ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರ್ತಾರೆ, ಬಟ್ ವಿ ಡೋಂಟ್ ನೋ. ಅದಕ್ಕೋಸ್ಕರ ಅದೊಂದು, ಮತ್ತೆ ಇನ್ನೊಂದು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ಗಳ ಬಗ್ಗೆ ಒಂದು ಗೈಡ್ ಲೈನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಇವನ್ ಇಫ್ ಇಟ್ ಕುಡ್ ಬಿ ಶೇರ್ಡ್ ಮೇಡಮ್.
ಇಲ್ಲ, ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ ನಾನು. For all these cases where men are accused for under these section 498 or domestic violence or anything, Supreme Court in this Arnesh Kumar versus State of Bihar has said that you make a family welfare committee and then you refer those cases there to try and see how best you can take action. Only when it doesn't happen there, then only arrest and everything should happen.
Okay, madam. Yes, madam. Thank you, madam. Thank you, sir.
Thank you.
So we can close, Basiraj.
Yes.
Okay.
ಸೊ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಅಕಾಡೆಮಿ ಪರವಾಗಿ ನಾವು ಬೆಳಕು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮವನ್ನ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಇದುವರೆಗೂ ಹಲವಾರು ದಿವಂಗತ ವಕೀಲರ ನೆನಪಿನಲ್ಲಿ ನಾವು ಕಾರ್ಯಕ್ರಮವನ್ನ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಮುಂದಿನ ದಿನಗಳಲ್ಲೂ ಕೂಡ ನಾವು ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯನ್ನ ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀವಿ. ಇದೇ ತಿಂಗಳ 17ನೇ ತಾರೀಕು ಕೂಡ ಇವತ್ತು ಉಪನ್ಯಾಸ ಮಾಲಿಕೆ ಇದೆ. ವಂದನಾರ್ಪಣೆಗೋಸ್ಕರ